Hello, my name is Benjamin Hart. I'm an American attorney and the managing director of Integrity Legal here in Bangkok, Thailand. As the title of this video suggests, we are discussing the I-134 Affidavit of Support, specifically in the context of the K-1 Fiancée visa. What is the I-134 Affidavit of Support? Well, as a necessary component of the visa package, which must be submitted to the United States Embassy abroad, here in Bangkok we call it Packet 3, you've got to submit an affidavit of support. In a K-1 context, you're dealing with the I-134 Affidavit of Support. Let me quote directly from the U.S. Citizenship and Immigration Services website, that's uscis.gov. 30.8, Affidavits of Support for Non-Immigrants, quoting directly, every non-immigrant seeking admission or extension or change of status must satisfy the inspector or adjudicator that he or she is capable of maintaining status and will not become a public charge. So that's the purpose of the I-134 Affidavit of Support. Such affidavits, although helpful in judging financial ability, are not legally binding. Form I-134 may only be used for non-immigrant cases. This is one of those situations where the K-1 sort of straddles the line between immigrant and non-immigrant visa cases. The K-1 was created to provide 90 days of lawful status for a non-immigrant fiancé to come to the United States, make a determination about whether or not they want to marry their American citizen husband, although they need to have the genuine intention to marry at the time they leave their home country and travel into the United States. They then need to make the determination as to getting married, and once married, they need to go ahead and file for something called adjustment of status. There are other videos on this channel which deal specifically with adjustment of status, specifically affidavits of support in the context of adjustment of status. Suffice it to say the I864 is associated with the adjustment of status process, and there's another video on this channel that I've made contemporaneously with this one that deals directly with affidavit of support in the context of an adjustment. But the thing that should be taken away from this video is, strictly speaking, the I-134 itself is not legally binding. That being said, it does need to be signed by the petitioner in the given case. And I think it's arguable, if not irrefutable, that purposely misleading, miscommunicating, or misrepresenting oneself in an immigration adjudication could lead to a finding of immigration fraud or a finding of a legal ground of inadmissibility associated with fraud and misrepresentation. So simply because the document itself is not legally binding does not mean that there is not a duty to tell the truth on the I-134. So first things first, let's understand that. But strictly speaking, the I-134 itself is not legally binding because it's this sort of interesting, narrow sort of aspect of the law where this K-1, although you can have immigrant intent, it's a dual intent visa essentially. One can have immigrant intent to remain in the United States at the time they're applying for it. You're not dealing with an I-864 Affidavit of Support, and for that reason, it's kind of a genuinely qualitatively different type of affidavit when compared to the I-864 Affidavit of Support. There's another video in the specific context of marriage visas and the I-864 Affidavit of Support and the legally binding nature thereof. I urge those who are watching this video to check that out to understand all aspects of this overall issue.